Yeah, can you see that red bar flashing? And then if you want to stop it, just press the same thing again. Alright, are you okay, Nick? Cool. And then if you want to rotate it, just move it.
Silence in the court, please. Are you going to ask for silence?
Silence, please.
Thank you, Usher. The case before the court today is, I know this is a cliche, but it is one of the most difficult the court has had to decide in recent times. This is the case of Crown on the application of Paul Hughes against the North Yorkshire NHS Trust. The facts may be briefly stated. Mr. Paul Hughes was involved in a traumatic accident and suffered consequent severe injuries which have left him for some time in a persistent vegetative state. Counsel appear before me representing the North Yorkshire NHS Trust, which have been treated him, and I would like to make clear that from the evidence it is obvious they have been treating him to a very high standard. No complaint is made of the treatment he has received. For a, as I understand it, a declaration from this court that it will be lawful for them to withdraw the artificial food and hydration, food and drink, which he is currently being given. As all parties concede, this will inevitably lead to his death by starvation within a not very short but not a very long period of time. Naturally enough, in those circumstances, the medical team are concerned about whether they may face criminal charges, some version of homicide, certainly manslaughter, possibly murder as a result of this, and they are very properly, as urged by the House of Lords, come to this court to seek that declaration. They have been represented very ably, if I may say, by various counsel. Also before the court, of course, is the official solicitor, Mr. Carrington, whom I allowed to address the court first, and if I may say, also did very helpfully. I mean no disrespect to counsel if I start with Mr. Carrington's submissions on behalf of the official solicitor, acting in effect as, I suppose, state guardian of Mr. Hughes, to speak up for his interests insofar as they might not be, and I say this with all respect to the Trust, not fully, it might be alleged by some, fully considered by the NH Trust in these times of austerity and cost cutting and so on, etc. I am sure such matters have not weighed anywhere with the NHS in deciding to make this application, I hasten to add. In short, Mr. Carrington put to this court 3 grounds for opposing the declaration that the NHS Trust wish. They submitted, firstly, relying on various dicta from judges deciding criminal prosecutions against doctors where there has been a death in, let us say, suspicious circumstances, to the effect that the criminal law applies to doctors as much as to anyone else. If a doctor causes a patient to death, then that is murder or at best manslaughter. That was his first submission. Secondly, Mr. Carrington submitted, again relying on a criminal case of Crown against Stone, where an elderly lady found herself under the care of some people who were at best neglectful of her. She died and they were successfully prosecuted for manslaughter. Mr. Carrington relied on that case as founding a general duty to continue to look after someone who is under your care. Broadly, if they are dependent on you for care that you can give, then you must continue to give it at risk of criminal prosecution. The application of that to Mr. Hughes was obvious. Mr. Hughes cannot feed or drink for himself, therefore he is dependent on the trust. Mr. Carrington then says, very well, just as the people in Stone were successfully prosecuted for their neglect, then he says the same would apply here. Thirdly, if I were minded to accept the argument put on behalf of the NHS Trust that I should not think of this simply as food and drink, I should think of this as an overall programme of medical treatment that is being issued to Mr. Hughes. If I were minded to accept that submission, then despite the habitual deference of Her Majesty's courts to the opinion of medical professionals, I should nevertheless, as it were, take the big picture view and say this is still going to lead to his death. Even if it's a cessation of medical treatment, it's still a withdrawal of treatment that will kill the patient. And he refers me to the case of Reed J. and the judgment, perhaps dicta, but very ratio-like dicta, of Lord Donaldson of Lymington. Quote, "There is a very strong presumption which exists in favour of preserving life. Withholding or withdrawing treatment can only be justified in the critical case where pain and suffering likely to be suffered by the patient exceeds the benefit of preserving life." Now, with all due respect to Mr. Carrington, that last quote flags up the difficulties we have in this case, in that to speak of pain and suffering for Mr. Hughes, so far as medical expertise goes, it's difficult to say he will suffer much pain, he will enjoy much pleasure. That's the nature of a persistent vegetative state. On the other hand, it's also difficult to speak meaningfully of benefit, and that was a point taken up strongly by counsel for the NHS Trust. If I may pick individual points from counsel, then there's Celine, who spoke first, then went, if I may say quite rightly, straight for that best interests of the patient point. That is the classic critical issue. What are the best interests of Mr. Hughes? And she pointed out, quite understandably, that the life that he lives now, and I think we must speak of it as life, the philosophers may want to ponder that question, but the law is we speak of him as alive, then the life he has now is very, very different to the life he had previously enjoyed until this unhappy accident. And as Ms. Celine argued, he was receiving, in fact, no benefit beyond the mere continuation of life. The remarks about resources were perhaps unhappy. I would like to think this is a purely medical and legal question rather than a question of budgets. I would be very sorry if anyone understood anything said in this court as implying that any future NHS trust could say the cuts are biting deeper, we can't afford this patient, therefore can we let them go, and so on. I'm sure Miss Celine did not intend to imply that, but I say that for the future. Mr. Darren followed on and led me interestingly to the authorities and the European Court of Human Rights, with us in so many aspects of legal life, and cited Article 2, the right to life, and I feel sure if I'd allowed him the time, he would have talked about Article 8, the right to privacy, drawing ideas, as has happened in American jurisprudence, of a right to personal autonomy from that. So I thank Mr. Darren for bringing in the human rights. And in that focuses us quite correctly on the position of Mr. Hughes himself and his best interests. And Mr. Darren very helpfully took me to the Airedale NHS Trust and Bland case, which I'm sure Mr. Carrington took as given my familiarity with, but Mr. Darren and others kindly reminded me of the details of, and took up these ideas about questions of quality of life, perhaps with a certain judicial prompting, of what was the quality of life that Mr. Hughes was now enjoying. And put it plainly as, if it is not in the best interests of Mr. Hughes for this treatment to be continued, then the court should authorise the medical team to withdraw the treatment and declare that it will be lawful for them to do so. Submissions ably backed up, if I may say so, by Ms. Fahima, who emphasised that Mr. Hughes has no prospect of recovery, and if I may say helpfully, in accordance with modern medical thinking about holistic care, drew the court's attention to the suffering of the family of Mr. Hughes as being evident. And again, I expressed concern about where that goes, but that's surely a relevant consideration. What is the benefit at all? And Ms. Fahima emphasised, if I may say entirely correctly, that the responsible medical judgment of the team treating Mr. Hughes, to which the court always gives great weight is that there is no benefit to him from continuing this. It would be inappropriate, therefore, to continue. There is therefore no necessity in doing so. And if I had lingering anxieties about the case, then Mr. Begg sought, if I may say successfully, to set them at rest by addressing directly, as counsel always need to do, addressing directly the cases relied on by Mr. Carrington. The Carrington's strongest cases seemed to include Stone, which I mentioned already, and Reed J. The earlier cases, with respect, I maintain my doubts, emphasised, rightly by Mr. Begg, that cases about fit and healthy people have little application here. Emphasised that in Stone, although the lady was unwell, she was likely to recover if treated correctly. That, in a sense, was the whole point of the manslaughter verdict. Whereas here, then, we are agreed, Mr. Hughes will not recover. No one has sought to argue there is any chance of that. And so on that basis, Mr. Begg argued that Stone was, with all due respect to Mr. Carrington, was irrelevant. He went on to emphasise that the dicta in Re J, as perhaps the judge had suggested earlier, but that is good technique from counsel. If the judge is suggesting something, feel free to adopt the suggestion. Then that the dicta in Re J are again, and I say this with the utmost respect to Mr. Carrington, who argued his case very ably, I would wish that clear, were perhaps not as helpful as they might at first sight have seemed. This balance of pain and suffering and benefit is essentially meaningless to Mr. Hughes. He is not, so far as anyone can tell, suffering pain. He will get no pleasure from the treatment. He just continues in this basic life. And the benefit for preserving life for him is essentially nil. And thus, although the use of the word euthanasia in this court did cause the bench some alarm, nevertheless, the phrase adopted by Mr. Begg, a dignified death, seems a fair description of what ultimately the medical professionals wish to allow Mr. Hughes, having concluded that, it's not for me to say correctly, this is the whole point, it is their clear, sincere, well-informed, slowly arrived at judgment that there is no prospect of his recovery, no benefit to him from continuing treatment. And I found helpful, I must say, the argument of Mr. Begg that this is an omission rather than a commission. Rather than thinking of time as one whole and indivisible thing, we think of rather as renewals of the treatment every time. After all, we don't need to eat continually. If I had to eat continually, it would be difficult to give this judgment. It would have been difficult for the counsel to make their submissions if they were having to eat at the same time. We have to renew our eating from time to time. So it may well be that that is the most helpful way to think this, that the trust are omitting to renew the feeding and letting, as was put, I think, nature take its course, and that Mr. Hughes would perhaps, regrettably, die, but die when he had no prospect of resuming the life he had formerly enjoyed. So with that, and with thanks to counsel on, if I can call them sides, then thanks to counsel on both sides, I make the declaration that it will be lawful for the medical team treating Mr. Hughes to omit to treat him further with food and hydration from the point they, in their medical judgment, see fit, that it will be lawful for them to do so. It will be so ordered. I will hear counsel if they want to address me further later on costs and the form of the order, but that, I believe, disposes sufficiently of the case for this hearing. Thanks to counsel. Thank you. Thank you.
All rise.